The following is a live broadcast of a Lone Star community radio program, recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and facebook.com/irlonestar. For more information on this show, please visit our show page at irlonestar.com/shows. To sponsor or donate to this program, visit our donate page at irlonestar.com/donate, or email us at lscrstudios@gmail.com, or give us a call at 936-666-1084. Lone Star Community Radio production and broadcast is possible by folks like you. So sponsor and donate today.
You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe, and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony and Cheryl. Tony Lynn Collins and Cheryl Ellsworth Jahani. We are here every Tuesday from 12 to 1 p.m. and we are discussing legal topics. 2 weeks ago, our topic was depositions, and we felt like we needed to, go a little bit more in depth on that and answer some more of your questions on depositions. And so this is going to be Deposition 2.
Yes, a little primer, and then we're going to recap a little bit what we discussed so that people can see the importance of depositions. Mm-hmm. And I'll just add a few little, spoilers. If you are asked a question in a deposition, and you're going to define it for us what a deposition is, but basically it's statements under oath outside of court that can be used in court. If you're asked a question by the opposing counsel in a deposition, because the jury is supposed to be there and it can be used in court, and your attorney or you don't object to it, then you've opened the door for that to come out. Your objection is waived. So you've got to be really, really careful to make sure that you've made the proper objections and you're listening to the question, because if they come out with something that may be privileged, that maybe a husband and a wife, had said in confidence, or a priest or whatever it may be, your Fifth Amendment right may be breached, and you or your attorney don't properly object to it, you've waived that objection.
Yeah.
So it's very, very important that you take depositions seriously, and that's why we're going over it today.
Right. Okay, well, a deposition in the law of the United States or examination for discovery in Canada involves the taking of a sworn out-of-court
that other United States.
Yeah. Mm-hmm. Oral testimony of a witness that may be reduced to written transcript for later use in court or for discovery purposes, what you just said. Mm-hmm. It's an out-of-court statement that can be used in court.
And it's sworn, and it is as though the jury is there. So don't get comfortable and just be casually answering questions to the other side, because a deposition is a series of questions that are asked under oath. And if you answer it differently in court, you will be impeached and your credibility will be attacked, and your case may be gone.
Yeah.
So,
well, your credibility will be gone.
You may lose your case, or you've lost a significant advantage if you answer a question that you may not have understood and objected to it being not a clear question in a deposition. Then it comes up again in court and you answer differently.
Mm-hmm. Deposition is the preferred term in the U.S. federal courts and the majority of the states. Some states also refer to a deposition as an examination before a trial, which is interesting. In almost all cases pending in the United States federal court, depositions are carried out under Rule 30 of the Federal Rules of Civil Procedure.
Which we're going to go over again in a little while, a little bit more information about Rule 30 and Rule 45, which is how you subpoena somebody that's a non-party for a deposition in federal court.
Mm-hmm, mm-hmm. And that's Federal Rule 45. Depositions usually take place at the office of the court reporter or in the office of one of the law firms. So they'll say, hey, we're doing depositions over here. They'll notice you and get you to come over to their law firm.
And even in this radio station, they offer the opportunity.
We talked about that 2 weeks ago. They're set up here. And the great thing about this is they've got this station doing depositions is they've got the recording equipment. It's a nice setup.
So if you're like me and you office from your house, which I do because I'm working 24/7, so I'm now I get to see my family while I work. Then if you don't want to bring people, and typically the deposition for that party is done at that office, if I don't want to bring people over to my house, the opposing counsel and all of their client, the people that show up for the deposition, then I would ask to have it either done at their office, which is not favorable. You don't want your party going into enemy territory.
Exactly.
Or I could ask that it be done here at this location, at a
That's
neutral place. You can also ask that it be done in one of the court like side rooms or jury rooms if it's available, because your judge is available if you have to get a judge to make a ruling. But I've not only done that a few times. I don't want to bug right now during COVID. I don't want to bug the courts. They've got limited space anyway. So this isn't a nice place to do it.
And, you mentioned COVID. A lot of depositions now are taking place via Zoom, and so you don't even have to go somewhere.
Right.
They'll just send you a link, and then...
Which that's sort of like the debate. I don't, I'm not really keen on having depositions by video or Zoom or some place where I'm not able to see them in person, even if it's videoed, because I don't know what they're looking. I don't know if they've got a cheat sheet that they're looking at. I want to see what they're looking at to answer questions.
Right.
So I'm not for that, but during these times you can do that.
Yes. Okay. So, let's see. Prior to taking a deposition, the court reporter administers some oath or affirmation, and that's swearing in. That's why these are under oath. You're
Right.
administered an oath.
And I think, like we talked about last session, I had done a 2004 exam, which is Federal Bankruptcy Rule 2004, and we actually did it with a notary that swore in the parties, and we recorded it on the phone. So
right.
A court reporter doesn't necessarily have to be there as long as you're sworn in and you can get it recorded, and everybody agrees to that method.
Oh, okay. All right. Attorneys for the deposing litigant, that means the person taking the deposition. Like, Tony, I'm deposing you, so you're on the other side,
Right.
and you are the deponent.
Right.
Okay? Attorney who has ordered the deposition begins questioning of the deponent. This is referred to as direct examination, or direct for short. Since nods and gestures cannot be recorded, the witness is often instructed to answer questions aloud. After direct examination, the other attorneys in attendance have an opportunity to cross. So if I'm deposing you after my direct to you, then your attorneys have an opportunity to
clear
cross.
things up. And I will just say that you rarely will cross somebody on a deposition. You will save that surprise for trial. I mean, you only have so many hours under the rules to depose somebody.
7.
And why would you be giving more information? Even if it's contrary, you've opened the door up. And so I would say 95% of the time, the side that's being deposed, their attorney given the opportunity to clear things up, may clear up if it's a question that they didn't object to properly, or need to make sure that it's clear for court.
For the transcript.
They may clarify it, but
so the jury can read this and
even
understand.
that, I've not seen it. Even if there's some question, I mean, and we'll get into this a little bit more later, but if the person that's being deposed is asked a question that they or their attorney believes has a privilege or is not clear, then they can ask that. They can direct their client not to answer the question. And later, the side that's asked it, which is all up, you get really crazy in depositions sometimes, as you know. The other side is mad because you want to answer the questions. Then they can move to compel. They can actually have a hearing later and compel them to answer it if they haven't. But that's how you can't not answer any questions, because that's just not the proper protocol. But if there's some questions they're asking you that are completely or not relevant, or they're asked in a way that maybe it is relevant, but it's a multiple, there's a lot of different, it's not a yes or no question, and normally it's yes or no. If it's, if you're the other side and you're an adverse witness, they'll ask you a series of questions that are answered yes or no, and it may not be a yes or no answer. Then a lot of times the attorney that's defending the deposition may say, tell their client not to answer, or even ask for a break, which is bad because when they ask for a break, a lot of times the attorney that is coaching their client on how to answer it. So that's kind of bad too. But if it's being videoed, that all comes out. That's why I like the videography part of it.
Right.
You get to see the whole thing, and the jury can see too the demeanor of the person and what's really happening.
That's good, Tony. Okay, so during the course of the deposition, we were just saying attorneys may object. There are two types of objections. There's form and I believe non-responsive, but it says the first is to assert a privilege and the second is to object to form. So you can object to.
And form has layers. There's different types of form, and you have to. If you object to form, the attorney that has asked the question should at that point ask what's wrong. Then ask for an explanation of what that is, because there's categories of form, and then if
under form are all of our objections: relevance, asked and answered, harassing the witness, all of these things. But your attorney will know those things. But I think, Tony, what you're saying is that in a deposition, the standard rules are you can object to form, you can object to leading, you can object to privilege.
Right.
That's what this is saying. And then also, there's an objection for non-responsive that the deposing side would make. Non-responsive means, Tony, I'm deposing you, I'm asking you a question, and you're not answering it. So now I object, non-responsive.
Right, so it's all on the record. And I will just cover something that we talked about just briefly a moment ago. Conduct during oral depositions and conferences. An oral deposition must be conducted in the same manner as if the testimony were being conducted in court in trial, because that's basically where you're using it. And the counsel should cooperate with and be very courteous to each other and to the witness, because it may very well show up in front of a jury. So be aware of that. The witness should not be evasive. It should not be unduly delay the examination. Private conferences between the witness and the witness's attorney during the actual taking of the deposition are improper, except for the purpose of determining whether a privilege should be asserted. Private conferences may be held, however, during agreed recesses and adjournments. That's typically when it should be done.
Right.
If the lawyers and witnesses do not comply with this rule, the court may allow in evidence at the trial statements, objections, discussions, and other occurrences during the oral deposition that reflect upon the credibility of the witness. So if you're misbehaving and the judge sees it, they may let the jury see the shenanigans going on at that deposition. So it's very serious that you don't just try to say, oh, object, and oh, we need to have a conference, because the judge may say, you know what, after she looks at it and you bring it to the judge's attention, she may say, you know what, this is all coming in because you were behaving improperly, and that's going to be your penalty. So the objections to questions during oral depositions are limited to objection, leading, and objection form. Okay, that's what we were talking about before. Objections, testimony during oral deposition are limited to objection, non-responsive. Okay, so I'm going to say that again. Objections to testimony during the oral deposition are limited to objection, non-responsive. These objections are waived if not stated as phrased during the deposition. That's very specific. You have 3 ways you have to specifically say it, or it is waived.
Right.
And they can ask you that in trial, and it may not even be relevant, but it comes in because it was said during the deposition. All other objections need not be made or recorded during the oral deposition to be later raised in court. The objecting party must give a clear and concise explanation of an objection if requested by the party taking the oral deposition. So the other side always should ask for an explanation. Why would you give that up? Or the objection
You mean
is waived.
when they say objection form, they say,
Right.
okay, what's your
what
objection?
is it? Right.
Relevance.
Right, because if
ask
you
and
don't
answer.
say, then you waive the ability to find out later what it was, and the objection sticks.
Right.
All right. Argumentative or suggestive objections or explanations waive the objection and may be grounds for terminating the oral deposition or assessing cost or other sanctions. And I know you've been in depositions before because we discussed it, where the other attorney is just downright insane.
Right.
All the decorum is gone, and they
Yes.
think they can bully you and
Exactly.
bully your client. And I've never done that, but I've seen it happen. And they're throwing their microphone down. I'm out of here. No, that's sanctionable. They can't, because they're mad about your questions. Just get mad and get up and leave. That costs everybody time, and it's judicially inefficient. So
And loss of reputation with the court reporter there. I've heard, and the videographer there, they remember that attorney who made that 16-year-old girl cry, and they and they don't like those
And
people.
these are the kind of times when you do go to the court. Don't let that go by. You go to the court, you ask for a hearing, that these things, the objections be reviewed by the judge, and that whether it be sanctions be made or whether the testimony come in over the objection and the demeanor of how they really behave, not how they're acting in front of the jury.
Yeah.
The officer taking the oral deposition will not rule on the objections, but must record them for a ruling by the court. So you have to say, the various statements, and I object, and this will be a ruling for the court at a later time. The officer taking the oral deposition must not fail to record the testimony because an objection has been made. Now, what we were talking about before was the instructions not to answer. I would love to give instructions not to answer to something I don't want to answer. That happens in debates. Wouldn't that be great if during the President Trump and Biden debates, if you could say, I'm just not going to answer that. No. Instructions, because my attorney told me not to answer it. If you've got a Fifth Amendment privilege, that's one thing, but you can't just not answer. An attorney may instruct a witness not to answer a question during an oral deposition only if necessary to preserve a privilege, comply with the court order, or the rules under the state or the federal jurisdiction that you're under. Protect a witness from abusive questioning if they're asking you about your sex life and it's a car wreck case, something that's ridiculous, or one for which any answer would be misleading, or secure a ruling pursuant to paragraph that we just talked about before, the objections. So if you know as the attorney, or if you don't have an attorney, which we always advise, because you really need somebody to be your wingman in these cases, because you're tense, you've got emotions, and you just don't know, because you want to answer the questions, you want to be honest, but it may not be in your best interest.
Right.
And you're giving up information that has no relevance whatsoever to the case.
And can be used against you.
So you really do need to have somebody sit in for you, or you want to postpone it or object to the deposition, because they're not required. Depositions can be compelled, but they're not required by law, because why not just have the testimony at trial?
Right.
It's the exact same thing.
Right.
Okay. So an attorney instructing the witness not to answer must give a concise, non-argumentative, non-suggestive, they can't be nudge, giving them the reason they're not going to answer or what they need to say, explanation of the grounds for the instruction if requested by the party who asked the question. Now, if you're not even paying attention and you ask a question and they just object, or they say, I'm instructing you not to answer, and you don't have the wherewithal for your client to say, I want an explanation, then you've waived that explanation. They just don't have to answer you. So you better step up to the plate and answer. Now, what we had experienced before was suspending the deposition. Somebody gets mad and they rip off their, like we saw in the Jeffrey, I always forget the guy's name. Epstein, thank you. Where he gets up in the middle.
Yes.
He doesn't want to answer, and we all saw it on the news where they're asking him about his sexual, his deviance.
His private parts.
That's what the case was about.
Right.
And he wouldn't answer it, so he took the fifth,
He just sat there and smirked.
And then he said, I'm done here, and just took his, you can't do that. And so unless you follow the rules. If the time limitations for a deposition have expired, and sometimes you're just waiting for that time to expire, or the deposition is being conducted or defended in violation of the rules, a party or witness may suspend the oral deposition for the time necessary to obtain a ruling. So they're going to get up and they're going to obtain a ruling. Well, you can't do that unless you have a reason. You can't get up if you don't like the questions. But I've seen it happen because people don't want to answer. And just like with Jeffrey Epstein.
Well, what'd they do with him? Because he sure got up and left.
I don't think the attorneys that were deposing him for the wronged victims, from what I could see, they didn't properly ask for the deposition to be continued and get a ruling on it.
Yeah, we didn't see that part.
Or we didn't see it because maybe they did. But if you don't go back, you're fighting. This is war. If you're not fighting for every bit of information to get out and not just be evasive and not come out, just like with a former Vice President Biden not trying to answer to his all those emails found on his son's computer. This is a smear campaign. That's not an answer. That's objection non-responsive.
That's right.
This has been. You have not denied that these are legitimate. That's what people try to do in depositions too.
Yeah.
So now he's not under oath, but if he was under oath, he wouldn't get away with that. And I wish the debates were under oath, but they're not. So good faith is required. An attorney must not ask a question at an oral deposition solely to harass or mislead the witness for any other improper purpose, which you just want to sometimes in a divorce. You're so mad. You want to find out.
Oh gosh. And your client wants you to so badly
and
to get in
the
there.
background, and you want it to come out that they've got several girlfriends on the side, and they've got several boyfriends on the side, they've got several dogs on the side, whatever it may be. You want this to come out, but it can't come out if it's not relevant to, let's say you've resolved everything but property issues. It's not relevant to the property issues if the child custody part's already been settled out in a mediation. So you can't ask those kind of questions, even though you really want to, or you get in trouble. Your attorney could be the attorney like us could be
Deposing us,
sanctioned,
yeah.
and the court can sanction the party. Sometimes it doesn't just go to the attorney. Oh, my attorney told me to do this. No, the party will get sanctioned too, and big monetary damages. So you got to be really careful. You can't. It's not the Wild West out there. Without a good faith basis, you can't get away with bad behavior. An attorney must not object to a question at an oral deposition, instruct the witness not to answer a question, or to suspend the deposition unless there is a good faith, factual, and legal basis for doing so at that time. So I needed to kind of clear that up for our listeners, that you can't just be a bully. You can't just, if things aren't going well, I'm going to stop this. You really have to follow the rules, because the judge may not only sanction the attorney, but sanction you, and it may show up if it's being videotaped, which I always ask for. It may show up in front of the jury, and then they can see what's really going on.
Absolutely. Okay, well, I guess we'll go on to Section 2. In our Section 2, Tony, what are we talking about?
Oh, we're talking about federal depositions, what rules you go to, just the decorum for the federal. The state and federal are a little different. They have different rules. We're following the federal rules of civil procedure or criminal procedure, depending on whether you have a criminal case, which is not very often that you get criminal depositions.
Yeah.
Are the civil depositions in state and sometimes in criminal. I will say this, with criminal depositions, you have to approach the judge to ask for it, whether it be a deposition for a witness because they're out of the country, or they were somebody that witnessed a murder and they don't want to come forward, or there has to be a very good reason to get sworn statements from a witness outside of court in a criminal case, because why not just do it at trial? And it's very seldom granted because the judge does not want to harass witnesses. But sometimes you need it because it could be they're in the federal protection program, or a state protection. The witness may be in danger. But you don't get the. It's difficult because although you have both parties there, I believe it's your Sixth Amendment right to confront your witnesses is a little bit different, and the judges just don't like it. I've asked for it before, and they always tell me no. And it comes up a lot with child sexual assault cases where you really need to talk to the doctors that examine the kid, or the experts, or CPS, or just the child, so that they're not in an environment, but they almost never let you even talk to the kid or anybody. So you've got to wait to trial. And those are really difficult cases when you're falsely accused of something like that. Because the kid is usually, a lot of times it does happen, but being a criminal justice attorney, I see more often than not, it's a false accusation by a parent or a grandparent that wants to get custody of the kid, or even during a divorce, and they're making it up, and they're really, really difficult to fight, because when it becomes criminal, the prosecutors can't take it lightly, so it just goes on forever. I know. It's difficult. Anyway, so the federal rules, what do you have on that? Anything?
No, I believe you have that stuff.
So on the federal rules of civil procedure, if you go to Rule 30, Rule 30 is the
deposition.
The rules for the specific rules that you can look at if you need to take a deposition in federal court. And it's a little bit different. Not most people, but many attorneys practice primarily either in federal or state, not both. And so that attorney may be well versed in the rules of that jurisdiction. But if you don't know the attorney you're hiring specializes in one jurisdiction or the other, and the rules are very different.
Right.
Although they kind of follow the same guideline, they are different. Then you may want to be checking up on your attorney. So you can go to Rule 30 just to be safe, like a car mechanic's fixing your car and you're not sure if it's the carburetor, the starter, or whatever. You may want to do a little Google search. Well, go to Federal Rule 30 because it tells you what the rules are, so you can kind of check up on your own attorney if you want to do that. if you don't have an attorney and you've been sued in federal court and you feel that it's critical that because you just can't afford it because attorneys are very, very expensive, you feel like you need to get a statement out of court that can be admissible in court, and you don't have enough interrogatories left. They didn't answer them. They were non-responsive. They made objections and just didn't answer anything like you see all the time. Then you can ask for a deposition. And the way you can do it, if you really just, you're kind of lost, but I've seen a lot of people do it. There's a lot of smart people out there. I mean, just going to law school didn't make us any smarter. It just gave us sort of a guidepost on what we needed to do and then the experience. But let's just say you don't have that, and you don't have the money, and you didn't quash the deposition, or they didn't quash the deposition you asked for, or you need it. Then you can go to the federal website. It's the United States District Court's website, and they've got interactive forms that you can fill in. And I printed one today. And if you look down the list that's available to you, you just go to the federal website. You go to forms, and they work beautifully. If you go to it, and I don't know where our camera is today. Let me see. There it is, right there. If you can kind of see this is what it looks like. It's an interactive form to get a civil deposition. To subpoena a witness for a civil deposition, right? You can do it for criminal too.
Now, this is a non-party.
Well,
is this a third party?
This is both ways. They've got the forms are set up so if you really are very new to this, you can. There is a form for deposition, and there's also another form to subpoena the testimony for a deposition for a civil action, which is the one that I just showed. And it literally has got a box, and you can just type it in as you go. It's like one of these federal forms that you fill out. And you put in there the courtroom date, where the case is, the number, the time and date you want them to be there. If you've asked them for a deposition date and they won't give it to you, then you fill that in. And then it's up to them. If they don't object, then you're going to have a deposition right where you said it was going to be. And what you do is you can call a court reporter. If you can't afford a court reporter, you can call a notary. Ask if it's really difficult if you don't know what you're doing, but you can do this. Get a notary as long as the statement is sworn, and I think the Rule 30 may kind of give you a guidepost, or the Google does now too. You get your witness sworn in, and then you can ask them a series of questions, but you've got to get them there first.
Right.
And to get them there, you can go to the federal website, and they've got forms you can fill in. These forms are great because they have discovery forms. They've got subpoena to testify at a deposition, subpoena to testify at a deposition, and to bring a subpoena duces tecum to bring documents. There's certain rules you have to comply with.
Time frames.
If you want them to bring documents, then you have to be specific, or they can say you didn't ask for the right one.
And you have to, with the documents one, don't you have to notice every party? It can't be just between you and the third party.
Well, if you're going to subpoena somebody for a deposition, then you need to, the other side's going to get your subpoena. Because
right.
Obviously
and see, that's what I don't understand. They're getting it anyway, but the rules say, and I think it adds 10 more days or something, so you can notice.
I think that's just for banking, but for financial institutions, you have to give 10 days notice before you can even get bank records. But I can't emphasize this enough. In state court, and then if it's also in federal court, if it has to do with a monetary damages issue and somebody owed you money they didn't pay, and that you had if you had a lien on it, like a landlord's lien or what have you, and they don't give you their bank records to show that they could have paid, I mean, those are important documents and they're relevant, then you've got to get those bank records up front. And so it's up to you. You can't just say, give them to me, they don't give them to you. And they're not admissible unless you can get them with a business record affidavit, or the bank representative has to be subpoenaed to come to court to authenticate them. They just don't come in because you've got them. So it's really, really important. Bank records are critically important for so many cases, particularly in state court for family law, for divorce cases and child support. So I can't emphasize enough that start early and make sure that your attorney's doing it right too, but get the bank records. And if you're going to subpoena them, either the state courts the same way. They've got, if you go to the Harris County District Clerk site, the Montgomery County District Clerk site, very, very good sites. They've got forms and they're interactive. Harris County has got like a library of them available. And you can just cross out the county name to Montgomery or Waller and fill in what you need. And if you can get it served properly, and you have to look at the rules too to make sure it's served properly, you can get a lot of information that way. And if you don't have their discovery in time for trial because you've missed the deadline, don't give up. You can still subpoena the records, subpoena the representative at the bank or the doctor's office or whoever, and get them to come to court with them. You may have missed your discovery deadline, but that doesn't mean that as long as you've got a good reason for not having it, times it might have been, a new
COVID.
It could be that your estranged spouse is smoking pot and you've got a new drug test. You need to get them drug tested. You can do it right there. You can tell the judge, these are the circumstances, and you can actually ask the judge, if you got a legitimate reason for it, and I've seen this happen, you can ask the judge to have somebody drug tested right there during trial, and they will stop the trial and have them drug tested. They'll bring somebody
Well, but
in.
as far as these records are concerned, say like you need the bank records, don't you need X amount of time before you subpoena them? So say like you missed your discovery deadline.
Yes.
Then
That's
you
why I'm
need-
saying start early, because
Yeah.
you got to get them 10 days notice, because the other side has to have within that 10-day frame
To
they can
object.
object. And if you haven't given them the notice and they never had the opportunity to object, and even though you got the records, now what do? You can't get them in unless you've got enough time to re-subpoena them and re-notice it properly. Then they can come in, or else you might be able to get it in through a different way. But if you don't give them that 10-day deadline, then you've not complied with the rules, and you'll be penalized for it. Now, here's some tips on federal depositions on the Rule 30. I just want to add real quickly that Rule 45 is your subpoena power. It tells you what the rules are in federal court to follow to get somebody subpoenaed that's a non-party. Rule 30 is for depositions. Rule 45 is for subpoenas. Now, Rule 30b6 of the federal rules authorizes a party to notice or subpoena a business organization, governmental agency, or other entity regarding designated topics of examination. This is critical if you're suing a company, and people sue companies all the time. Walmart, slip and falls at HEB. I haven't sued HEB, but I'm just saying that if you've got Tillman Fertitta and all of his, litany of restaurants, you've got to sue that corporate entity, because they, although the corporation may preserve some liability, it doesn't exonerate the corporation from bad behavior. So you need to get those people in, and that goes to their attorneys too. There was a legal case that it was in the United States Supreme Court, and for the life of me, I can't remember the case right off. I think it was U.S. versus Logan, but an attorney for a corporation was subpoenaed on a wrongful termination suit, and the attorney was, before the suit even came about, was telling parties within the corporation, guiding them, giving them legal advice. Well, the person that got fired wanted that attorney who gave that advice to testify, because he felt like he was improperly telling the superiors of this person what they could do to get him fired, or whatever. For whatever reason, they need the attorney there. And it ended up in Texas. And this doesn't apply to all states, but in Texas. So it was a Texas case. It was Texas Supreme Court. They said that the attorney did not have a privilege, that even with the Apex Doctrine, that the attorney, because it wasn't an attorney-client privilege to the corporation because it occurred outside of the lawsuit, had to testify. And so, and they argued to the high heavens that this was completely improper, that their own legal counsel would have to come forward and testify and answer questions. And without a privilege, you've got to answer them.
Right.
But they said that it had nothing to do with the suit itself, or it was relevant to giving them facts toward the suit. And so they made the attorney for the corporation come testify.
Wow.
And they objected. That was one of their points of error on appeal. And all the way up to the Texas Supreme Court, they said, no, this doesn't get overturned. This should have come in, and it's going to in the future. Attorneys for corporations on a limited basis can be deposed. They can't get around it just because they are representative of the corporation. Now, if you want to get a deposition of a corporate head, and you can't bring Sam Walton in. I think he's dead anyway now, but you can't bring in somebody that's the head just because you're trying to harass the corporation.
Right.
They have to be involved. But a lot of times the head people are involved. So you need to bring them in.
Or at least they make comments. They can make comments that bring them in.
Even if it's one statement, you can still bring them in. Doing so requires the party be noticed or the non-party be subpoenaed to designate one or more officers, directors, or managing agents, or designate other persons who consent to testify on its behalf. This can be very useful and productive discovery tool for attorneys familiar with this rule and its comments and its history. And And so here's some tips on it. You want to read Federal Rule Procedure, Civil Procedure 30 and 26 in its entirety. Know them through and through, so you can get that corporate entity or that I guess head of the company in, or whoever
the representative.
It may be. Right.
Okay. Well, this is a question. Say like there's this corporation and they've got all these employees, and you want to talk to that employee, but that employee is not a party to the suit. The corporation's a party to the suit.
Yeah, but they were a fact witness. They're coming in.
Yeah. So
they're a fact witness. They're coming in. You can depose them. It's when what they try to get around the corporations. If they're not a fact witness, you're only trying to bring in
information
somebody,
about the company,
because you think it might. Heads of corporations are afraid to get anything because depositions are so broad. They may have to say something that is completely not relevant, but it may lead to something relevant, and they don't want to disclose it. And there's, let's say, trade secrets. It may not be trade secrets, but they may say that, and so you can get another hearing on it. But don't be afraid. You may need that person. They may be a fact witness, and they're going to come in if they're a fact witness.
And would you depose them or notice them under the 30B-6 because they're an employee of this corporation to get that fact witness, or would you just subpoena the fact witness?
No, subpoena the fact witness. Just straight up. It's not up to you to make the objection. It's up to them. The first two, reading those two different civil procedure codes and the federal rules, seem obvious to an attorney, but consider how many discovery disputes still arise out of the refusal of attorneys to stop making boilerplate discovery objections.
Oh, no kidding.
Despite the fact of all the different amendments in the federal rules that have been changed recently in the courts and in the legislature. A thorough knowledge of the extent of the text of these two, Federal Rule 30 and 26, and their committee comments. Read the comments too, and it's all available on Google if you just Google it. May help convince the opposing counsel to stop their bad behavior. If not, the magistrate or judge will appreciate the fact that you have read and understand the rules. But judges always appreciate people that are well informed. They're not just trying to come in there and say, "Oh, I'm not represented. I don't know what I'm doing." Judges hate that because judges are people too, and they know how easy it is now to get it through Google.
Right.
Now, if you contemplate taking a Rule 30 deposition, start those discussions early during the 26F conference, which is the Stop Trial Scheduling Conference. Consider whether the discovery plan needs to include a provision for how a deposition will be viewed for purposes of duration and limitation and the permitted number of discovery depositions. It is better to have the judge provide guidance early in the case. And of course, in federal court, it's very different from state court because you've got a trial conference to set the schedule, and you're discussing this up front. So you really should know who your witnesses are, whether you're being sued or you're the person suing. Because when you discuss it with the federal judge, which is going to be in person or through Zoom, you're going to make a lot more headway if they trust you and believe that you're seriously taking their guidelines and their rule, the 26 conference seriously, and you're prepared to talk about who you need to depose and why and for how long and what. The judge is going to ask you, what do you need to ask it for? Maybe not in detail, but you better know.
It's been so frustrating with all of this COVID stuff and the depositions needed and all of that stuff, and just the doubt of the efficiency of depositions that's been taken on Zoom or when you're not in the same party with them. Do you think that judges would give extensions just because of
for the right reasons? Judges, I have found, particularly federal judges, because they're not elected, they don't have a bias, they're very reasonable, much more so than the elected state officials, which to me, in many cases, have a bias because they've got constituents who have supported them.
And they're
in their
running for
campaigns,
election.
And they're always rerunning. Now, when individuals designated to testify by a party, or when you depose them, you can require them to bring documents. You really want to take advantage of this, because if you didn't get them in your request for production because of their ridiculous objections, and they didn't answer your interrogatories because maybe they said it wasn't clear enough,
they objected too much,
then the deposition is very important to get these documents now. This is your second bite at the apple. And if it's recorded, the judge can see how you've asked for it and why they're not giving it to you. It is always the best practice to conduct discovery well in advance of the deposition to obtain documents to be used in the deposition. So you want to ask for it well in advance. If they don't give it to you, you're asking for it again. This is your second bite. Before you have to do an expensive motion to compel, ask for it for the deposition. Judge, I asked for it here. I asked for it again. I asked for the deposition. And now I want sanctions against them for not giving me the very specific information that I know they have and they're hiding. Okay? So you want to ask for it in advance and have it given to you. It gives you really a big leg up if you've asked for it before the deposition, but you could ask for it again in these forms that you can fill out for a ducis tecum to get the documents again. Be very specific about how you ask for it, because they can say it was too broad or whatever. But, they can make up a bunch of objections for not giving you if you don't know exactly what you're looking for. Are broad enough. Bank records. I mean, you may not know what you're going to find in them, but those bank records have a treasure trove of information for your trial, particularly in family court. That's not necessarily in federal, but it could lead to
in
it.
corporate law, too.
Failing to do so will waste valuable time during the deposition. Now, beware.
Failing to do what? Not ask for documents?
The deposition, ask for the documents up front in a previous discovery request. So when there's a lawsuit going, you want to start asking for discovery almost immediately. You can't do that in federal court, though. A lot of judges say, do not start the discovery process until we've had our scheduling conference.
Right.
I don't even want you to go there, because you may have special exceptions. There may be some motions we need to knock out of the way. I don't want you, we're not even going to go there until you've talked to me first. Federal is a little different from state. With state, you go for it immediately. Right away, start getting those out, because there's deadlines, and you're moving really fast in state court. Judges like to keep their dockets clean. So don't wait and procrastinate, because you're going to run out of time in your docket control order to get the discovery you need, and then it's going to be your own fault. The judge is going to be mad at you. Now, beware the opponent who pressures you to take a Rule 30 deposition, which I don't like depositions. I avoid them.
I know.
Because I will move to compel before I will, particularly if it's my client being deposed, because I don't want their business out on the public record, because they can file the depositions and the experts in the public record, and it can be about anything, venereal disease or whatever, things that aren't even relevant to the case. So you don't want your dirty laundry washed down. That's why a lot of people don't like lawsuits. If an opponent pressures you to take a Rule 30 deposition before you've conducted written discovery that you feel is necessary, the judge may not like it, and if they move to quash the deposition, the judge may say, you had a less invasive, more efficient way to get discovery than a deposition, which is taking away from someone's time. They may be a doctor. They may be an accountant. You're taking away pretty much more than a full day of somebody else's time if they're not a party to the case, even if they are a party to the case, because now they've got to pay the attorney's fees. They've got to pay the court reporter. If we're here, we've got to pay the time for using this facility fee. So depositions are very expensive, and that's why I kind of avoid them. I like deposition on written questions. It doesn't limit you to the number of questions you can ask. But I do like it when you're getting near the end of trial and it should have settled and those people are lying. I really do like depositions near the end, right before a trial, because it may persuade a settlement, because they're lying, and now they know they've got you on film, dodging questions and looking bad for the jury. Based on experience, this can be a signal that there are facts or witnesses that your opponent is trying to shield or otherwise protect from discovery if you're pressuring a deposition. The louder the protest, the greater the chance that something or someone with an as yet undiscovered information is being protected. So basically, if you're being, I don't know why that would be. If somebody is pressuring you for a deposition for no reason, something's going on. If you're being pressured for a deposition for no reason because discovery's already been conducted and there's nothing out there, something's going on. So that's always a big red flag.
Well, Tony, I was going to ask you, because we're running out of time, to wrap this section up, how do depositions usually go? You and I have talked about this before, and we've talked about how they want to depose people all in one day or all in 2 days. So say I've got 7 people that I need to depose, right? So how would that typically go? Would I notice them for a deposition, and then they turn around and notice my clients for a deposition, and we've got 7 hours per party that we can.
Well, it depends on which level of discovery that you've designated in your pleadings. You will have different times. If you've got an accelerated case, you have a very limited time for depositions.
Right.
But a more extensive case, you have a certain number of hours. If you've got multiple parties on either side, the judge may grant more hours. So it's all relative. But in general, you're going to have about 4 to 6 hours per deponent.
Right, right. And so would you do those back to back? 4 hours I'm going to do
Typically you do because
Joni, and then in the afternoon I'm going to do Fred. Or...
Only because everybody usually it's just more efficient for the attorneys involved to put all of your the witnesses to be deposed on or near the same day and back to back. But there is no rule on who goes first, whether you're the plaintiff or the defendant, or who asks first. It's always beneficial to be able to ask the questions first, in my opinion, because then you know what questions you need to follow up on later or what they're actually going after. So there's some benefits and there's some strategies involved. And without the specific facts, I don't know which direction you want to go with it. But I will say this about compelling a witness: a party may compel a witness to attend an oral deposition by serving the witness with a subpoena under in state law Rule 176, and it's governed by Rule 199. Okay, so remember those for state of Texas law. 176 is the subpoena rule, and 199 is the procedures. If the witness as a party are retained by, employed, or otherwise subject to the control of the party, however, service of the notice of the oral deposition upon the party's attorney has the same effect as a subpoena for a non-witness. So if you're subpoenaing somebody's fact witness that works for a corporation and the corporation's already represented, then you can serve that subpoena via email just as service to the corporation. However, if they're a total non-party or they've quit that corporation, they don't work for them anymore, so they're not under that umbrella, then you have to use the rules of access subpoena power and go through the proper process to get them served. Improper service is an amazing objection. A party or a witness may object to the time and place designated for the oral deposition and get a motion for protection. They can object to how it was served on them. It's an improper service. But importantly for this segment, if you're served properly, and you don't have time, or they didn't talk to you first about the notice that you get, you can move to quash the deposition within 3 days of receipt of that, and automatically the court will quash it. There's not even a rule.
No
it's an absolute.
asked.
But it has to be within 3 days. Don't wait. File that motion to quash immediately, because it will be quashed. And you can do that 100 times. The problem you have is if you're just trying to dodge the deposition, the other side will move to compel it, and the judge will order within a certain amount of time you will be deposed. If they wait too long outside of the docket control order, the judge won't order it, or generally shouldn't, but sometimes they do. So there's a lot of little rules and kind of games that you play with depositions. I don't like them. I think they're overly expensive for my clients who usually don't have a lot of money.
I know.
I think that if the other side is asking for a deposition in lieu of doing the written discovery first, they're only doing it for harassment because it's running my client's bill up.
Right.
Unnecessarily. If I need a deposition because I know that, I think the main reason for getting a deposition is when you have asked for discovery, if I'm asking for it, or if they're asking for it from me. If you've been trying to get discovery, but they've been evasive, they haven't given you what you wanted, they're doing everything within their power not to give you the one thing that you're looking for, that one question, then I think you need a deposition. And what you do is you can call a court reporter, and sometimes you can save money, like we discussed a few weeks ago. You can get the court reporter to videotape the whole thing, and if you get something good out of it, you can save money by having only that part of it transcribed.
Right.
So that's another, because we're dealing with lots of people here listening to our show that are pro se, don't have a lot of money, can't afford an attorney, have looked
And that
at
is
everywhere.
much less expensive, I know.
Yeah.
And they're trying to represent themselves because they just can't afford an attorney. Are we out of time? Is Dick giving us notice? No, not yet.
We have 5 minutes.
Okay.
We're great.
Oh, okay, great. Yeah, so that's
Now let me talk a little bit more
info.
about notice real quick, and then I'm going to let you ask me some frequently asked questions and other things. If a notice or subpoena is issued under Rule 30, and again, Rule 30 and for the federal rules and Rule 45 are very similar to Rule 176 and 199 in the Texas rules. So be familiar with those particular sets of rules, as well as Rule 26, if you get deposed or if you believe you need to depose somebody. Rule 30 requires the notice or subpoena describe with reasonable particularity the matters of the examination, and that's in the federal rules. And you need to say just in general what you're covering. If the topics for examination are not adequately particularized, a court may deny a motion to compel. the deposition, or it may quash the deposition notice. So that's another objection. You haven't told me what you want to talk about, so I'm going to object to it. I've not seen that happen very often, but it can happen if you just say broadly what you just want to depose them. In state court, I don't know that you even have to really say what it's about. I've never seen that. But in federal court, you have to be more specific with particularity, or and there, as you know, federal court's very formal. I love federal court. I think it's more refined than the state court rules. I don't know why, but it's just, I think it's an easier court system to deal with, just in general. It's very predictable. Maybe the way it turns out won't be as predictable, but there's just less legislative, controversy, because you don't. I guess you'd have less people changing the rules all the time. In addition, a court may limit a Rule 30 notice if it requests the organization to designate one or more deponents to testify on topics that are overly broad, vague, or ambiguous. So you have to be careful when you're doing corporations, and they usually have really expensive corporate attorneys. And usually, you are suing a corporation if you're a little guy, and let's say CarMax or ExxonMobil has done you wrong, or you got hurt or something. Usually personal injury attorneys will be very up to date, and if you get a good like the Hammer, or a good personal injury attorney, they'll know all of these rules. You don't have anything to worry about. But if it's something small, like small claims court, which is criminal and civil, and you may be representing yourself, well, also know this: in small claims court, you can't. A corporation has to be represented by an attorney. So if you have a small company you've set up, corporation, you can't go in there and say, I'm going to represent my corporation because I was sued under my little, Secretary of State corporation I set up. No, you can't do that. You've got to get an attorney. So JP Court's got its own little particular rules about that kind of thing. But other than that, JP Court's you want to follow the exact same rules in state court, in JP Court, on your own. You don't need an attorney. You can represent yourself. But look at these rules. The judges aren't attorneys necessarily. A lot of them are. But they will really appreciate you knowing what you're talking about when you go in. Conferring or attempting to confer with the opposing counsel, if there is a dispute whether topics are described with reasonable particularity, may avoid a hearing. And in JP Court, they'll send you to the back room to talk with the opposing counsel, the other side, a lot of times right before trial, because they don't want to have to deal with the trial. JP Court bench trials are pretty normal. Jury trials are unheard of. But I've had jury trials in JP Court. They're not courts of record. So if you're going to appeal a ruling that was not in your favor in JP Court, you're going to start all over again in county court, which is, you do have to follow the rules. Because it's not a court of record, even if it was sworn, you're going to have a witness. The only way you can show that they lied under oath in JP Court, because you don't have a record, is if you had a witness that heard them say that, and it's not hearsay. If certain rules, if you can overcome certain rules. But if it was in a court of law and they were under oath, then I believe that you can get that in. And that's happened before. People will lie to save their skin all the time in JP Court or otherwise. Case law for Texas states that the duty to represent and prepare Rule 30 goes beyond the matters personally known to the designee. Let's see. The party noticed or the non-party subpoena must prepare the designee to the extent that the information is reasonably available, whether from documents, past employees, or sources. So that's basically, you've got to prepare. If you're representing somebody, prepare them for the deposition. And we had a whole long list of topics to prepare. And we may have a couple of minutes to go over that. Do you have that?
Tips and strategies. Yes. This one. Tips to prepare, research the law and keep the theory of the case in mind.
Yes.
Learn which objections are acceptable. You've covered that.
But have your cheat sheet ready.
Absolutely. Be organized. Strategies for taking a deposition. Do not blindly agree to the usual stipulations. Okay. Our listeners, the usual stipulations, what Tony was talking about: objection form, objection leading, and objection unresponsive. And so the usual stipulations those are going to be our three, right?
There's no such thing as a usual stipulation, though. So never
So you need to get
that.
clarity on what those are. What are the usual?
Just ask, because that's very broad. I agreed to the usual stipulations. I don't think attorneys know what they are.
No, they don't. And in different jurisdictions, they don't. They're different.
Right.
Follow up. Effective lawyers explore nuances. That's a big part of the deposition, is the follow up.
If something comes up and it's something you didn't even think think you may be going down a rabbit trail you never even knew was going to help win your case. So you're just having a discussion, but you have to beware because it's so casual at that point, and if it doesn't look like it's something that may hurt or help, then you still have to be on your toes, whether you're the person being deposed or the attorney. And remember, your Fifth Amendment right is critical, just like Jeffrey Epstein. You can, if you think you're going to get in trouble or not sure, you can always object with a privilege. Attorney, even if you don't really even know, just a husband-wife privilege, the clergy privilege. Fifth Amendment's a big one because there's so many things that you can get in trouble for in the law that, and of course, the Fifth Amendment is when you have a right not to incriminate yourself, so you don't have to answer a question, even in a civil deposition.
Win and walk away. Whether you won, act like you won and walk away.
And I will say this also, in preparing for a deposition, if your attorney, if you've got somebody that's got a flat rate or they're not really prepared or whatever, what you want to do for them, and as an attorney, I always do this, I have a list of questions that align with the documents I'm asking the questions about, and I have them in order. That's how I organize. Okay. And then we're getting, Dick is saying that we have run out of time.
Okay, all right. Well, we want to thank you for listening. I think we wrapped up depositions. That was really good, Tony. We want you can listen to us, our podcast on Google Play or iTunes. Tomorrow it will be available, and we want to remind you.
Serve God by serving others.
Have a great week.
Today's show was recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and all rights and ownership are reserved to Lone Star Community Radio. For more information regarding this program and Lone Star Community Radio, visit us online at irlonestar.com. Lone Star Community Radio is Montgomery County's community radio station, serving the community with local programming on TV, radio, and online. If you enjoyed today's program, please support us by sponsorship or starting your own show. Contact us today by phone or text at 936-666-1084 or email the station at lscrstudios@gmail.com.